is now in session.
Thank you, Mr. Hivner. Judge McClarty and Judge Frierson and I welcome you to our virtual courtroom. And we will conduct this just like we were all together in person. If you have any glitches or anything, we'll stop the proceeding till it gets right, and then we'll go on. So don't worry about that. Mr. Hivner, would you please call the case?
William Maurice West Jr. versus Julie A. West.
Mr. Lefkin, I believe you're the lucky person who goes first.
Thank you, Your Honor. This is somewhat of a convoluted case. This is the second appeal in this case. There's three major issues, I would say. We cited 6 in our brief, but there's 3 that are important more than the others. And that is the issue of jurisdiction, the issue of standing, and the fact that there represents itself in this case a collateral attack on the probate jurisdiction of the Chancery Court of Knox County. The other 3 issues all deal with violation of due process, failure of the trial court to uphold my client's rights under Rule 12, assigning a shorter appeal period than the Tennessee Rules of Civil Procedure allow under Rule 6201. And then there's some issues as the cash bond following the first appeal. For the benefit of the court, I'll just give a very short history. This matter concerns detainer warrants that were filed in the Knox County General Sessions Court. There are 2 of them. The first detainer warrant was filed back in September of 2016. The second one was filed in May of 2018. The first warrant was filed by my adversary, Mr. Garrett, as attorney for Mr. West. The second was filed pro se by Mr. West. In between those 2 dates, there was an agreement of counsel between myself and Mr. West to hold this matter pending the completion of the probate process. I don't know why, but I figured that at some point Mr. West got tired of waiting on that and filed the second warrant pro se.
I thought it was just pending the outcome of some motions.
Well, there was an agreement between counsel to hold it until certain matters got completed. That's correct.
And those matters did get completed, and then subsequently the second detainer warrant was filed, right?
The first warrant was never dismissed and was still pending at the time the second one was filed. The second one was filed pro se. We finally got around to arguing those cases in the Knox County General Sessions Court, and they were consolidated for the purposes of that hearing in the Knox County General Sessions Court. And after argument of counsel, there was no trial, there was no introduction of evidence, but after argument of counsel, the General Sessions Court dismissed both of the warrants. And part of what we had argued at that level, and part of what we argued in the Court of Appeals and the first time, and also in the Knox County Circuit Court, the trial court, is that you've got a problem in this case of a pending case doctrine. The Sledge case that was decided and cited in my brief by the Court of Appeals in 2019 is the most recent indication on that, but you're not supposed to have a second case filed on the same circumstances and the same parties when a first case is pending. So that's an issue in this case.
Even though the first case was about the will and the second case is about removing someone from the property?
I'm not talking about the cases in the probate court. I'm talking about the fact that there were 2 pending detainer warrants at the same time. And those were consolidated for hearing and dismissed at the same time, both by the Knox County General Sessions Court. Mr. Garrett then filed an appeal of this matter to the Knox County Circuit Court. And we repeated the motion to dismiss that we had filed at the General Sessions level and the Circuit Court level. And that motion talks about the pending suit doctrine. That motion talks about the fact that there's no jurisdiction and there's no standing. And at a hearing on October 15th of 2018, Judge Davis dismissed this case a summary order in nature, even though there was no pending motion other than my motion to dismiss. We filed a motion for new trial to alter and amend that decision by the court. It was denied on December 14th of 2018, and that's when the first appeal to this court arose. That appeal ended in a remand to the Knox County Circuit Court for a findings of fact and conclusion of law. That never took place. There's no trial in this case. There's no hearing. There's no introduction of evidence. What took place was that the judge of the trial court put down a findings of fact and conclusion of law without holding a hearing. And we filed a motion for new trial to that matter, and it was denied. But in the process of filing that motion for new trial, we filed a certified copy of the last will and testament that had been filed for probate in this case.
What is the status of the probate of your petition or your motion in probate court?
Nothing has happened since the end of the first appeal. In the probate court, there's a pending petition which Judge Weaver has ruled is proper and timely filed for my client's rights as a survivor, a widow surviving her husband's death, that include homestead. There is also a petition or a motion filed in the probate court to remove Mr. West as the personal representative due to the conflict of interest that is shown by this case. Neither of those matters have been heard. There is a setting on April 28th in front of Chancellor Weaver where we will probably get into some of those issues, but neither of those matters have been heard. After the trial court put down her findings of fact and conclusion of law and denied our motion for new trial or to alter and amend, we filed the second appeal on June 2nd. All of this concerns the motion to dismiss that was filed by Ms. West in this case. And even though there's not been any trial or any testimony or any evidence, the issue concerns Ms. West as a legatee of the probate estate and as a surviving widow with a petition that has been ruled timely filed for her survivorship rights. The plaintiff in this case, Mr. West, is in a personal capacity. He has not filed these detainer warrants in the capacity of the personal representative of the estate. He's filed them personally. We have argued at all times that creates a conflict of his fiduciary duty to the estate and to my client as a legatee, and it creates a conflict of interest for his counsel. The issues in this case, jurisdiction.
Well, explain one thing to me. What is her rights then as to the property, the actual physical rights that she has to this property at this point?
She has a pending homestead petition. She has a claim filed against the estate that includes over $90,000 for personal property.
But that's against that's the rights in the estate, but the actual property though, what rights did she have?
Homestead. Surviving widow in possession, and they have never paid her homestead. It has not been set out by the court. Both Mr. Garrett and I have announced to the court on different circumstances that the real estate is probably going to have to be sold for purposes of dealing with that homestead and the other issues in the case, including the claims in the case.
Okay, that gives her a right of possession at this point?
They have never filed anything in the probate case to remove her, to make her pay rent, to establish or contradict any of the rights that we have asserted in this case. None of that has been carried on in the probate case.
The probate case has decided that he owns the property, right?
No, that issue has never come before the probate court.
Okay. How does he claim ownership to the property? Is it through the probate court or what?
No, the last will and testament of the decedent, Mrs.
Gave him the property.
Husband,
okay,
which is now part of this record. After the second appeal, it's part of this record. In paragraph 3 of that will, it devises all real estate that is owned at the death of Mr. West, the appellee. But in paragraph 7 of that same will, it states that all real estate is to be kept in the estate and used for the administration of the estate. So there's a major conflict in the last will and testament that has never been addressed by the probate court.
Counsel, as I understand, you made reference to the possibility that the real property may need to be sold. Has there been a suggestion in probate court that the estate is insolvent?
There has been an oral assertion by Mr. Garrett that it is, and there has been a motion filed to sell the real estate that is going to be heard by Chancellor Weaver on April 28th.
But is that an issue before the probate court?
It should be, yes.
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 It is?
Yes. Our argument as to jurisdiction in this matter is that this is an improper forum for the detainer warrant. The detainer in Tennessee involves two statutes, TCA 29-18-102 and 29-18-104. The first is forcible entry. We don't have that in this case. The second is unlawful entry. And the statute and the case law all talks about relationships between landlords and tenants. That is not the situation in this case. And because of that, it was improper for Mr. West, whether he had filed it as a personal representative of the estate or personal. This just isn't a detainer situation. She lives in the real estate by virtue of her rights as being married to her husband and has lived there since his death. In the same matter, we attack the standing. The issue as to who's going to end up owning this real estate is yet to be determined by the probate court. And here he is as personal representative of the estate, and he turns around and files this detainer warrant as an individual. He doesn't own the real estate. There is a potential device in a will that is still in administration, but as in your Schubert case that was cited just a few months ago, there's been no deed out of the probate administration to him for reception of this property. He just doesn't have standing. In addition, as both of you have asked me in this afternoon, these are all issues for probate administration. These are all issues in the Knox County Chancery Court. And yet when this matter came before the trial court, even though there was an acknowledgement she knew nothing about probate administration, and we had argued that it was a collateral attack on the probate administration, she went on and put down an order dismissing this case in a way of a summary nature. So we argue there's no jurisdiction, there's no standing. These are issues for probate court, and this entire matter should have never been filed.
Was the real property titled solely in the name of the decedent?
Yes.
Was there any action taken to transfer this detainer warrant initially to probate court?
No, I did file a motion for certiorari in the General Sessions Court because I just thought it was improper. And that was to be heard on the same date we came into the General Sessions Court. And Judge Emery just said, I agree with you. This isn't a detainer matter. He just dismissed the case. He said, this isn't a detainer matter and these shouldn't have been filed.
Okay. Thank you.
I'm out of time. I reserve 3 minutes.
Yes. Thank you very much, Mr. Garrett.
Yes, thank you very much, Judge Bennett and Judges Frierson and McClarty. I appreciate the time this afternoon, appreciate the ability to speak with you. Mr. Lufkin is trying to do in this argument what he's been consistently trying to do throughout the course of this entire matter, and that is convolute it to the point that it's just almost impossible to get a good grasp on. In essence, what we have here boils down to a pretty simple situation, and that is that there was a will contest action that was filed way back in 2013 and worked its way through the system and came to trial in 2016. And there were 2 wills that were proffered for probate, one by Mr. Lufkin's client, who was not his client at the time, and one by my client. And not the probate court, but the Chancery Court, as the court of contest, found that my client's will, was the operative testamentary intent of the decedent and granted it to be recognized as the appropriate will. The other will was cast to the side. So therefore, the devise that's clearly within the context of that will states that the property is to be devised to my son. It says in specific part, I give, devise, and bequeath all of my property, real, personal, mixed, whatever kind, where situated to my son, William Maurice West Jr. to hold as his property. Now, since it has that clear language of devise, then our argument is that this case clearly falls under the rationale of the in re estate of Metatol case, which I've cited in my brief, in which case found that language that was substantially the same. In that case where it said, I give, devise, and bequeath all of my real estate to my son, basically almost verbatim the same language, that was held to immediately vest the property into the son in that case. And in our case, my argument has been and remains that the property at issue became owned by my client, Mr. William Maurice West Jr., as soon as the will contest matter became final and non-appealable, which was in November of 2016. So
what about the language Mr. Lufkin points out about property remaining in the estate till the, go ahead.
That would seem to be a conflict, but that very same language was contained in the Metatol case as well. And the court, in that case, this court, found that the language having to do with the devise made it the property of the devisee. As you know, property in the state of Tennessee has to be owned by somebody. It can't just sit out there in limbo. And there are two ways that property is owned. It's either owned by virtue of a deed, a grant of a deed, or by muniment of title in a will. So what happened was, as I say, and our argument is that when this will contest action became final, that property at that moment vested in Mr. West. Now, to be sure, Mrs. West, Mr. Lufkin's client, has some claims that she's made and she's filed in the probate court, and those are up to be determined. But those are in the nature of election against a will, homestead allowance, which is a $5,000 allowance. And according to Pritchard on the law of wills and administration of estates, section 675, it says prior to being set apart or assigned, homestead is a right hovering over the whole land that does not rise to the dignity of an estate. So she doesn't have any underlying fee ownership in this property. She has claims against the property, and those are going to be adjudicated in the probate court. And those—
excuse me for interrupting. Is there an issue before the probate court that the estate may be insolvent?
There is an issue. I have filed a motion to order that the property be sold, yes, on the basis of its insolvency under the statute. And that, as Mr. Lufkin correctly stated, is up for hearing before Chancellor Weaver on the 28th. And Mr. Lufkin has attacked that on some procedural grounds. So whether or not Chancellor Weaver will order that, I don't know. But I'm asking that happen. And yes, the issue is that there is an insolvency situation. But what we're asking for, respectfully, in the circuit court action, the detainer warrant action, is not the ability to pull a property away, to sell it. We're just asking to possess it. All we want is possession of our property.
This action could not have been filed in probate court.
I don't believe it could, Your Honor. I believe the statutes pretty clearly state that actions of detainer of this nature have to be filed either in sessions or circuit court. I didn't find anything that said that the probate court would have concurrent jurisdiction to entertain such matters. It would have been nice if it would have, and then we could have had it all in one court and dealt with it. I would have loved that, but I didn't see any authority that permitted that. What I do see is, in countervalence to what Mr. Lufkin is arguing about the fact that it's not really an appropriate detainer matter, are sections 2915-101 that says where the action is to recover real property, ejectment or forcible or unlawful entry or detainer may be brought. And that's also parroted in section 29-18-106. And section 29-15-102 says that any person having a valid subsisting legal interest in real property and a right to the immediate possession thereof may recover the same by an action of ejectment. So if ejectment equals detainer equals unlawful detainer, all these other actions which statutes clearly say it does, then we have done what we should have done in filing this detainer action first with the Sessions Court and then appealing on up to the Circuit Court. So that, again, there's been no collateral attack on any probate jurisdiction. We certainly did not ask Judge Davis to interpret a will. He's made some arguments in his brief and elsewhere that the judge improperly interpreted a will, which is not the case at all. she just simply stated that as he agreed, and I won't read it to you because I put it in my brief very boldly, that Mr. Lufkin himself agreed to the fact that the will, that's the operative will, grants title of the property to my client. There were 3 separate exchanges between he and Judge Davis on the day of trial where he agreed to that. And so by virtue of the fact that he agreed to the ownership issue, if a party has ownership, then they have right to possess. So there was no need to go forward with any fact witnesses. I had my client there that day in October of 2018. He was going to get on the stand. We're going to introduce the will. We're going to do whatever we needed to do. But once counsel, Mr. Lufkin, admitted to Her Honor Judge Davis that the will was the 2003 will that gave the property to my client, she quite properly said, well, there's nothing for adjudication. There's no facts to be adduced. You have agreed as a matter of law that this property belongs to Mr. West, and therefore he's entitled to that property. And then again, with respect to this so-called inconsistency, which not so-called, I guess it is one, but according to N. Ray Medital, when there's language of devise contained in a will, which clearly there is here, it's his. There doesn't need to be a deed. There doesn't need to be any separate transfer to affect that purpose. I don't know if I can't recall whether he actually, he made a lot of arguments in his time there about some violations of the Constitution, violations of the rules of civil procedure and all those sorts of things, but I've dealt with all those arguments in my brief. There were none. Judge Davis did not violate either the Tennessee or the federal Constitution in any way. He made a big deal about that at one point she ordered that the judgment for possession would take effect within 10 days of the date of the entry of the judgment. And his argument was it should have been 30 days. And actually there's a statute, Tennessee Code Annotated 2918-126, that does recite 10 days. But even if it should have been 30 days, there's no harm, no foul, because by virtue of the bond that she put up, she's still in possession of the property. She's still sitting out there today. Almost 7 years after her husband's passing, 8 years after her husband's passing, she's still sitting on the property. So there's no prejudice to her there. I suppose I should get into briefly this argument that he makes regarding the cash bond, which he may get into on his rebuttal, having to do with the bond that she put up, which is required by Tennessee Rule of Civil Procedure 62.052, which says that anytime there's a judgment for possession of property, the other side, in order to stay the effectiveness of that judgment or the institution of that judgment, has to put up a bond to secure people like my client for the payment of the use, occupancy, detention, and damage or waste to the property from the time of the appeal until delivery of possession. That's pretty clear. It looks pretty clear to me in the rules of civil procedure that that's appropriate and that it was put on for the right reason. Mr. Lufkin has made arguments to the effect that it's punitive or that perhaps because we didn't ask for rent that shouldn't be that way. But that has nothing to do with whether or not we asked for rent. That has to do with the fact that we were granted a judgment for possession, and then we got to wait until disposition of this appeal before we can actually take possession of the property. So that's what that's all about. As for, he made arguments on service of process. I think those are easily dispatched with by the cases that I've cited in my brief, including Dixie Saving Store versus Turner and Landers versus Jones, that when a party comes in, starts arguing the merits, they waive any issues of service of process. He certainly has come in and argued the merits quite vehemently throughout the course of this litigation. As for the prior pending thing, what happened was I was going to have the old detainer action put back on the docket, and the Sessions Court Clerk's Office told me we don't do that. It was been on hold for a year and a half. You're gonna have to file a new one. So a new one ended up getting filed. And then when we appealed it, when, as he says, the Sessions Court judge did dismiss both detainer actions. And then when we appealed it up to Circuit Court de novo, we only appealed the latest one. We didn't even worry about that previous one because obviously the latest one is what we were looking at. And I guess that's where his service of process arguments come in. But at any rate, we respectfully ask that you uphold Judge Davis's judgment for possession, that you affirm it in all respects, and order costs against the appellant. And unless your honors have further questions, I'll yield the remainder of my time.
With reference to jurisdiction, is it your client's position that the probate court through Chancery Court does or does not have any jurisdiction with regard to possession of the property?
It's my position that it does not have any jurisdiction with regard to possession of the property. That's why we filed what we did in Sessions Court, the detainer action that we did. I don't find anything in the statutes that grants a probate court the right to grant possession. Now, for sure, they have, and we've asked that they order that the property be sold because of the insolvency situation. That ipso facto would require a dispossession of the tenant who's in the property by virtue if they agree with us and they order it to be sold. But we filed what we did in Sessions Court and into Circuit Court because of my reading of the statutes. Hope they're right, but my reading of the statutes is that that's where the jurisdiction lies for the possession issue.
Your client's position is that exclusive jurisdiction is in Sessions and Circuit Court.
Correct. We've never asked for that in
That's
probate
for
court.
possession only then you're talking about.
Possession only, yes, Your Honor, that's correct. Possession only. And I might add that by virtue, we see this as a win-win, and Mr. Lufkin's never quite agreed with me on this, but if we have possession of the property, meaning my client has possession of the property, he can get in there and be better able to fix the problems that need to be fixed, and they're numerous. We did have an inspection back in 2007 under order of the probate court that allowed us to get in there and inspect the property. And there at that point in time, there were numerous problems, deficiencies found with the plumbing, with some of the
That's not
construction.
before us though, right?
I'm sorry.
That's not before us, right?
That's not, but I mean, you're right. That is not before us, but the probate court has ordered these inspections, but we've never asked them to outright give us an order of possession. That's correct.
Okay.
Any other questions? No. Thank you, Mr. Garrett.
Thank you.
Mr. Lufkin, you have your 3 minutes.
The first thing I want to say is in response to Judge Frierson's question about the jurisdiction of Chancery Court. I happen to have been around for a while, so I know that Judge Frierson used to be a chancellor. The statute that Mr. Garrett talked about combining the words injectment or detainer, is a statute that gives not only Circuit Court, but Chancery Court absolute right for injectment. This is not a probate matter. You can take almost everything that Mr. Garrett said, and it would have been good arguments in a probate setting. This is not a probate setting. This is a detainer setting. This is a detainer in Knox County General Sessions Court ×2, appealed to the Knox County Circuit Court, and then my motion to dismiss denied, and the case ruled on by summary judgment for possession. And the court doesn't have jurisdiction because the General Sessions Court did not have jurisdiction. There is no jurisdiction of detainer. There is no forcible or unlawful entry in this matter. If, upon appeal, Mr. Garrett had amended his pleadings and pled ejectment, then the Circuit Court perhaps could have reached that issue. But that didn't happen. There is no amendment to the detainer warrants that were appealed de novo to the Circuit Court. He mentioned the fact that the probate court has allowed inspections. Pray tell why a person that owns a piece of property comes to probate court and requests the right to inspect the property. Why does that person come to probate court and request the court to allow to be selling the property? What he is trying to say is that his client, by virtue of the will, ignoring paragraph 7 that says it stays in the estate as an asset, has the right to possession as the lawful owner of the property, but that has not been determined by probate court. These are probate questions, not detainer questions, not Circuit Court questions. These are probate questions, and that's where all of those motions should have been filed. They might have been good arguments in probate. Well, someday we'll get there. But my point is, Mr. West, as an individual, not as a personal representative, but as an individual, had no standing whatsoever to bring these detainer warrants, nor did the Court of General Sessions or Circuit have jurisdiction to entertain them.
Okay, thank you. Thank you both.
Thank you.
And Mr. Hivner, would you please adjourn court until 3:30?
This honorable court is now in recess until 3:30 p.m.
Thank you, Mr. Hedner.
Thank you.